Assalamualaikum warahmatullahi wabarakatuh. My name is Noratasya binti Hassan Shuhaimi. So in this video, I'm going to present my case review for the case of Pacific Forest Sdn Bhd and WEN-CHIH and another 2009. This case can be found on Malaysian Law Journal, volume 6 at page 293. So the decision for this case was given at Federal Court Putrajaya by Zaki Azmi, Chief Justice, as well as Hashim Yusof and Muhammad Ghazali, Federal Court Judges, on 7th of September 2009. So, overview of this case, there was a sawmill company named Vermet Sdn Bhd, owned by the appellant, Pacific Forest Industries, which was referred as the first defendant. And the respondent, WEN-CHIH and another, which were referred as plaintiffs, were the directors and shareholders of the company. But then they sold their share to the second defendant. So on 28th of August 1996, the first defendant owed money amount of 10,134,000 ringgit from the plaintiffs. And on 12th November 1996, the first defendant by letter agreed on method of settling the money owed plus interest, which was 11% per annum. By the plaintiff shall purchase timber products from the first defendant at price consistent with prevailing market price, which in total would cost the same as would cost the same amount as money owed plus interest plus the agreed interest, and the product shall be ordered within 10 months and shall be delivered by 4 shipments. But on 6 November 1997, the plaintiff had only placed one order for the first defendant's timber product, and the factory closed down on July 1998. So in federal court, the court decided to uphold the decision of trial judge in dismissing the plaintiff's claim as it was premature, and departed from the decision of Court of Appeal as the contract was not a frustrated contract. So initially at High Court, the plaintiffs claimed under breach of contract, and the defendants argued that plaintiffs had only ordered 1 shipment out of 4 shipments, despite the first defendant was ready and willing to supply the timber products. But there was no claim of frustration pleaded by the parties. But then, unsatisfied with the Court of Appeal decision, the first defendant appealed to the federal court by raising 2 issues. And for the first issue, whether it is open to an appellate court to find or hold that a contract has been frustrated, notwithstanding that such had neither been pleaded nor canvassed in the trial court, and neither pleaded as a ground of appeal in the appellate court. So the court referred to few cases to illustrate that a court cannot decide on issue which was not pleaded by the parties, and if the court did so, then it would breach the legal maxim, audi alteram partem, which means to hear the other side. But the court can highlight any new points that he think might be relevant to the parties and give them opportunity to further submit their claims or arguments on that particular points. Okay, so in this case, none of the parties pleaded the contract under frustration. Thus, the court was wrong in deciding that the contract was frustrated. And then the court held that the statement made by the Court of Appeal constituted as a wrong statement of law. So moving on to the second issue on whether the doctrine of frustration in the law of contracts recognizes the failure of the parties to a concluded and valid sale and purchase agreement of a product to agree on the sale and purchase price as a frustrating event when the agreement provides for a price consistent with the prevailing market price of the product. Okay, so first of all, what is said to be a frustrated contract is a contract in which, subsequent to its formation, a change of circumstances renders the contract legally or physically impossible to be performed. Thus, the doctrine could be applicable to discharge the contract. And the court referred to a few other cases. And for the test for frustration, Lord Radcliffe stated in the case of Davis Contractors Ltd and Farham UDC 1956 that if the circumstances render a thing radically different from that which was undertaken by the contract, meaning that if the parties were to perform their contractual obligation, then it would render to a thing radically different from what they originally undertaken by the contract. As the Latin maxim, non hac in federa veni, which means it was not this that I promised to do. And in the case of Ramli bin Zakaria and Government of Malaysia, 1982, Abdul Hamid, Federal Court Judge, had stated that even if there was a change of circumstances, but no fundamental or radical change, then the contract does not amount to frustration, as if it is not impossible to be performed, then the contract is not frustrated. And the court referred and followed to a few other cases. Similarly, in Contracts Act 1950, subsection 2, if after the contract is made and the act to become impossible or by reason of some event which the promisor could not prevent unlawful, then the contract becomes void. And for that ambit in section 57, Gopal Sriram, Judge Court of Appeal, had further explained by outlining 3 elements that amounted a contract to be frustrated. First of all, there must be no provision has been made by the parties, because if there was, then they must follow it accordingly. And second, the event relied upon by the promisor must be something in which he or she is not responsible. And lastly, the event must be such that renders it radically different from that which was undertaken by the contract. If any of these elements does not fulfill, then section 57 of Contracts Act 1950 will not bite. So for machinery or guideline, if a machinery or guideline has been provided in the agreement between the parties, but it is difficult to be followed, then the court can apply any method in interpreting or by substituting their own machinery. But and the court referred to the case of Sudbrook Trading Estate Ltd and Eggleton 1983, where there was machinery provided in the clause, but the lessor does not follow it accordingly, then the lessor should be ordered by the court to perform another contractual obligation on their part. So in this case, a mechanism was clearly provided by the parties to determine the price, which was a price consistent with the prevailing market price. And then the court held that the agreement was not frustrated and the appeal was allowed. So my analysis and opinions. First of all, I think the significance of this case is that it could be set as an example that despite the existence of the doctrine, the parties to the contract could not easily discharge their performance of their contractual obligation unless provided that they fulfill certain requirements. So I referred to a few other cases, such as the case of Hong Leong Bank, Berhad and Tan Siew Nam and another, 2014, and Maxis Cigars in Berhad and Silver Concepts in Berhad, 2005, to illustrate that even if there was a change of circumstances, but if it is not impossible or unlawful to be performed, then the contract does not amount to be frustrated. So my opinion, I agree with the federal court decision. First, on the case that on the first issue, which frustration was not pleaded by the parties, then the court cannot decide on that issue or decide that the case was the agreement was frustrated. And on the second issue, even if the plaintiff pleaded for frustration of contract, they cannot, even if they plead, it is not, their contract, the agreement does not amount to frustration, as the parties had already agreed on a method of settlement, which means that a mechanism was clearly provided, which was consistent with the prevailing market price. It is indeed difficult but not impossible to do, as it was what the parties had consented to. Otherwise, they would have set the exact price from the beginning. And then the product shall be ordered over the period of 10 months and shall be written for shipments. But then the plaintiffs had only ordered one. Yeah. So nevertheless, not only that, no event was arisen that could trigger the payment of cash. Thus, I'm of the opinion of the federal court that the contract was mainly breached and not frustrated. So I think that's all from me. Thank you so much.